Hi, my name is Soyed Saim Shafiq Joy. My student ID is 0351987. This is my individual video presentation for the module called Public International Law. So let's get started. The question for the presentation is, the state of Mandalore is considering being a party to the International Covenant on Civil and Political Rights, in short, ICCPR. The Prime Minister of Mandalore approaches you as his legal advisor for advice on the following matters. Number one, there is a first optional protocol to the ICCPR. Explain to the Prime Minister what is a protocol. Secondly, a member of the cabinet suggested that if Mandalore becomes a party to the first optional protocol to the ICCPR, they should enter a reservation to the Article 1. Explain to the Prime Minister what a reservation is and whether Mandalore can enter to a reservation to the said article as suggested. To understand the protocol, we must understand what a treaty is. In legal terms, a treaty is defined as an international agreement concluded between states governed by international law and recorded in a written form. It establishes legal rights and obligations between the participating states. As Dominic McGoldrick states, an important feature of the ICCPR is that it is a universal instrument which contains binding legal obligations for the states parties to it. The main purpose of treaty or convention is to maintain peaceful relationship between the nations, whatever their culture or rules are. In international law, a protocol is a supplementary instrument or agreement that complements and enhances a principal treaty. It may clarify, alter, or expand the primary treaty's terms. A treaty, according to the Vienna Convention on the Law of Treaties, Article 2 sub 1 sub a, is an international agreement concluded between states in written form and governed by international law. When a protocol is meant to create rights and duties between treaty parties, it is regarded as an important element of the treaty. So, protocol is like a rule or agreement to hold on to the treaty signed by the both parties. The International Covenant on Civil and Political Rights, in short ICCPR, first optional protocol is an extra instrument that allows persons to file complaints or messages to the Human Rights Committee about the alleged violations of their rights under the ICCPR. The United Nations General Assembly approved the first optional protocol on December 16, 1966, and it went into effect on March 23, 1976. It strengthens the ICCPR's implementations and enforcement measures by introducing a complaints system for the persons who claim to be victims of violations of their ICCPR protected rights. Individuals or organizations that have exhausted all available domestic remedies may send written statements to the Human Rights Committee, a body of independent specialists tasked with monitoring the ICCPR's implementation. The committee evaluates these communications and gives opinions on whether the ICCPR's rights have been infringed. It should be noted that not all states that are signatories to the ICCPR are also signatories to the first optional protocol. To be bound by the requirements of the first optional protocol, states must officially sign, ratify, or accede to it. Reservations to treaties. When a state becomes a party to a treaty, including the first optional protocol to the International Convention on Civil and Political Rights (ICCPR), it may contemplate making a reservation to certain of the treaty's terms. When a state ratifies or accedes to a treaty, it may make a unilateral declaration to exclude or amend the legal ramifications of certain treaty articles in their application to the state. Reservations allow states to stray from the treaty's commitments to some extent. Remarks that aim to change a state's commitments under a signed treaty are known as reservations. They enable nations to modify certain duties. Some argue that in the context of human rights regime, Reservations are simply attempts to avoid international obligations where they would be consequential. States might utilize reservations to ease requirements that could otherwise make ratifying a particular treaty prohibitively expensive. Briefly stated, reservations serve as a technique to increase treaty design flexibility. Let's look at some examples of reservations. Saudi Arabia made a reservation to the meaning of discrimination against women in the Convention on the Elimination of All Forms of Discrimination Against the Women, based on Islamic law. Egypt made a reservation to Article 14 of the Convention on the Rights of the Child (CRC) concerning the right to freedom of thought, conscience, and religion subject to Islamic law principles. Germany lodged a reservation to the meaning of treaty in Article 11 sub 1, stating that it does not cover agreements negotiated within international organizations. The first optional protocol of ICCPR. It is crucial to emphasize, however, that reservations to treaty provisions, particularly those relating to fundamental human rights, are subject to specific terms of the treaty and customary international law. Reservation to Article 1 talks about human rights. The Human Rights Committee, which monitors the ICCPR's implementation, has taken the position that reservations to provisions concerning fundamental human rights, such as Article 1, the principle of non-discrimination, are generally incompatible with the ICCPR's object and purpose. The Human Rights Committee has urged nations to restrict or retract any concerns that jeopardize the ICCPR's essential principles and protections. While some governments have made reservations to ICCPR articles, the committee thoroughly examines and such reservations to ensure they do not impair with the treaty's overall efficacy. Article 1 states that everyone has the right to self-determination. They have the right to freely select their political status, to pursue their economic, social, and cultural growth because of this freedom. All people may freely dispose of their natural riches and resources for their own purposes, without regard to any duties emerging from international economic cooperation based on the principle of mutual benefit and international law. A population must never be stripped of its own means of subsistence. So, from the first section of Article 1 of ICCPR illustrates that everyone should have the right to think for themselves. No matter what the political parties are, they should have the right to choose their own political status. Because of this self-determination, free will, the economic, social, and culture will grow. And in the second section, anyone can spend their natural wealth for their own purposes without answering upon anything regarding economic cooperation based on mutual benefits and international law. People can spend their wealth as they want for their own benefits. It is vital to emphasize that obligations to Article 1 of the ICCPR are not authorized in general. The right to self-determination, as stated in Article 1, is regarded as a basic and inalienable right, and reservations to this provision are incompatible with the ICCPR's goal and purpose. The first optional protocol of ICCPR is given below. Protection and promotion of civil and political rights. The ICCPR aims to safeguard and advance the enjoyment of civil and political rights for all individuals. These rights include the right to life, freedom of speech, freedom of assembly, freedom of religion, and the right to a fair trial, among others. However, the issue with using a reporting system to carry out the Covenant on Civil and Political Rights stems from the fact that, unlike the Covenant on Economic, Social, and Cultural Rights, the former covenant imposes the obligation to ensure that the rights recognized in the covenant are immediate and not progressive. Non-discrimination. The ICCPR seeks to ensure that all individuals are protected against discrimination in the enjoyment of their civil and political rights. State parties are obliged to guarantee these rights without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Respect for human dignity. The ICCPR emphasizes the inherent dignity of every person and the need to respect and protect their dignity in the exercise of civil and political rights. State parties are required to ensure that individuals are treated with dignity, both in law and in practice. Fourthly, right to remedy and justice. The ICCPR recognizes the right of individuals to an effective remedy for violations of their civil and political rights. State parties are obliged to provide accessible and effective remedies, including judicial remedies, to ensure that violations are readdressed and justice is served. Last and not the least, international cooperation and progress. The ICCPR calls for international cooperation among the states to promote and protect civil and political rights. It also encourages the progressive development of international law in this area, emphasizing the importance of continually advancing human rights standards and norms. So it can be said that reservation to Article 1 is not recognized as a goal of ICCPR because it simply talks about human rights, where goals of ICCPR are totally different. To be more specific, there are no examples of a nation making a reservation to Article 1 of the ICCPR because such reservations are often not recognized. The Human Rights Committee, which oversees ICCPR implementation, has regularly stated that objections to Article 1 are incompatible with the treaty. Many countries in which ICCPR forms part of domestic law, only one country, USA, find it non-self-executing. So, in conclusion, it can be said that Mandalore must carefully assess the implications and potential ramifications of making a reservation to Article 1 or any other ICCPR provisions. If Prime Minister of Mandalore becomes a party to the first optional protocol to the ICCPR, they cannot enter a reservation to Protocol 1. Given the core nature of Article 1 and the non-discrimination principle it embodies, it would be advisable for Mandalore not to enter a reservation to Article 1 of the ICCPR, as it may be seen as incompatible with the object and purpose of the covenant and could potentially undermine its effectiveness. These are the bibliographies of the journal articles that have been used in this work. So that's all from me. Thank you.